Thanks very much, Oswald. So, hello everyone. My name is Alex Milner-Smith. I am the co-head of the data and privacy practice at Lewis Silkin, one of the UK members of Ius Laboris. Today, we're talking about subject access requests around the world. And we've obviously titled the session today, Access All Areas. Can't obviously be all areas. We only have speakers from five jurisdictions, but we're going to try and cover as much ground as we can. For those of you who've attended these sessions before, you might have heard them referred to as speed dating. We've obviously moved on from that, but what we're trying to do here is do a whistle-stop review of what is the right to subject access within the data and privacy context, and then give some color from various jurisdictions, just so you come away with a greater understanding generally of subject access, but also understanding some nuances from some jurisdictions, and then hopefully it will help you as you approach international compliance with subject access. So without further ado, I will introduce the speakers. Before I do that, please do ask questions throughout using the Q&A function that you can find on the Zoom tab. I will either save them to the end, or if they're relevant to what's being discussed at the time, we'll try and answer them live, as it were. So you know who I am. We've also got Roxana from Romania, our Romanian partner firm. We've got Inge from our Belgian partner firm. We've got Lionel from our Singapore partner firm, and Linda from the Irish Ius Laboris member, who also happens to be one of my partners from Lewis Silkin. Now I'm going to start and set the scene for about 10 minutes before we go through and hear from our speakers. And you know, this introduction slide is very, very simple. I am going to read what these various important people and bodies say. And first comment is from John Edwards, who's the Information Commissioner in the UK, so the data regulator, the chief data regulator in the UK. And the SARs, he says, are his most important objective is to safeguard and empower people by upholding their information rights. And later on in that speech that he gave, he said that one of the fundamental elements for him was a data subject's right to understand what someone is processing about them and be provided with that information so they could understand it, so they could also test the compliance of the controller processing information about them. Now, that's obviously in the UK, and I'm a UK lawyer, and I can obviously become a little bit fixated on the UK, but you can see this is similarly repeated by the European Data Protection Board, the European Data Protection Board being the regulator's regulator within Europe, for want of a better word. And they say the overall aim of the right of access is to provide individuals with sufficient, transparent, and easily accessible information about the processing of their personal data so that they can be aware of and verify the lawfulness of processing and the accuracy of the processed data. This will make it easier, but is not a condition, for the individual to exercise other rights, such as the right to erasure or rectification. So again, the EDPB really regards it as a cornerstone and fundamental right. And you can see there, slightly worryingly, they make reference to other rights that can emerge from it, you know, the right of erasure, the right of rectification. And for those of you who are still within the European Union, obviously not the UK, actually the right of access is also set out in the Charter of Fundamental Rights of the European Union. So not only is it set out in some of the legislation that we're going to talk about in a moment, it is also in that charter. So it is, dare I say it, akin to a human right or a fundamental right. So already we're setting the scene, regulators are interested, and it's really quite an important right. But to bring it even more worldwide, and try and raise our eyes a little bit from just Europe with a capital E, I've got a quote there from the OECD. And actually, the OECD has been really quite trailblazing even since the 1980s. I think they released their Article 108 or Convention 108 paper in 1981 on data. But they're very trailblazing in terms of trying to push the data agenda worldwide. My goodness, my screen has gone off, but that's... No, it's back. Thank you. Sorry. Push the data agenda worldwide and not just sort of focused on Europe. And they say the right of individuals to access and challenge personal data is generally regarded as perhaps the most important privacy protection safeguard. So what I'm trying to get at here is that, you know, SARs are just very important. All regulators, all international bodies regard them as such. And although, you know, the majority of speakers today are from Europe, we'll hear from Lionel that actually all the principles that we sort of know and love, or hate, depending on what you think, in Europe are actually very similar, even in Singapore, you know, a totally different jurisdiction. And were we to have a speaker from Japan, were we to have a speaker from Brazil or South Africa or similar, a lot of these principles are similar around the world. There'll always be nuances, and that's why we've got our speakers here. But the right of access is something that is going to grow all around the world. And indeed, even though those of you that are familiar with CCPA, in California, that has the right of access broadly. All of the new US state laws that are coming in place over the last year and over the next 2 or 3 years all have an element of right of subject access. So I've been talking about what is subject access. I'll tell you what it is from a European perspective, but broadly this is mildly similar all around the world. Lionel is going to talk about the differences in Singapore, obviously. But Article 15 of GDPR, UK GDPR, which for now are the same thing broadly, it gives an individual, a data subject, the right to request any and all of their personal data that a data controller processes about them. And it also allows the data subject to allow to access other supplementary information. You know, who has the data been sent to? Why are you processing that data? How long do you keep it? Do you send it outside the European Economic Area or the UK? Now, obviously today, in terms of the types of SAR, we are going to be focused on employment SARs because this is a jus laboris session. However, in my practice, we deal with SARs in the workplace, of course, but we deal with many hundreds of SARs in the marketplace, consumers who are annoyed about something and they might file a SAR against an organization. We also deal with lots of wild and weird and wacky SARs in relation to professional services, from ex-clients to current clients to opponents to just people off the street. And indeed, dare I say it, and we are being recorded, but I'm not revealing too much, we, Lewis Silkin, even receive SARs from all these strange esoteric sources. I am going to narrow it down, though, now to employment. And SARs are routinely used in employment disputes. Now, I've written on the slide that they're most commonly used as a tactical weapon to obtain early disclosure, you know, shall we say pre-action disclosure, or a litigation fishing exercise, we might say, or to gain leverage in a settlement negotiation. If you file a SAR on a Friday night, maybe, and you work out the timeline properly, maybe someone has to respond on Christmas Eve, and maybe they don't want to do that, and maybe they don't want to spend 40 hours dealing with the SAR, maybe they don't want to waste money on lawyers, and maybe they'd rather increase their settlement offered from £10,000 to £30,000 or euros. Now, that's obviously being very cynical. But if we were to go back to the first slide, the fact is SARs are a fundamental right. Subject access is a fundamental right. So being less cynical, maybe lots of employees are just very interested in how someone is processing personal data in the workplace, and they want to know that. So the problem is that although cynically there might be underlying and other reasons for why a subject access request is brought, you as the data controller and as the responder have to really treat it agnostically from a motive perspective. You just have to treat it as a black letter law subject access request and answer it. And obviously getting it wrong, and this is potentially the leverage that employees can use or workers can use, can result in legal action. You know, we have seen in the UK a number of cases brought by individuals in the courts, the High Court, and indeed the County Court actually, but in relation to SARs and failures in SAR compliance. Now, nothing has resulted in enormous compensation, but there have been orders from courts that that data controllers have to do X, Y, and Z. So there's an enormous cost to going through the court procedure there, and of course it's terribly damaging reputationally as well. We're going to talk about some cases today, which is wonderful for us, but it's not great to be the person on the other side of that case and always referenced as precedent. Although you'll see in Lionel's case in Singapore that they seem to redact case names. Lionel's going to explain that a little bit later. But secondly, regulatory action, which is not how you pronounce regulatory action, it is potentially there. The fact of the matter is that in most of the SARs that we deal with in the UK, and we probably help clients with 200 or 300 a year, most data subjects do write to the ICO or in India's case, the IDPC, and complain. Because if we look at the cynical reason why subject access is being used, they never get the data they want because it probably doesn't exist. And maybe the employer hasn't paid them the settlement money. So it's in their interest to go to a regulator. And these poor old regulators are inundated with complaints about SARs that they have to deal with. Now, it may be the worst that happens is you get a slap on the wrist and you're just told to do a little bit more searching and so on. But if this happens 5 or 6 times in a year, a regulator might look at you further and they might say, good Lord, this company has an issue in terms of its processes. And as I'm afraid we've seen on a few occasions, a SAR can actually lead to complaints about other things because of the other information you have to provide about retention, about transfers outside of a country. Suddenly, the data subject can say, do you know, I'm not going to complain about the SAR, I'm going to complain about retention. And it can suddenly blossom or balloon into a much more serious issue. So that's what a SAR is and some of the issues that we have with SARs. Very quick canter through timescales before I'm going to come over to, I think it's Lionel actually first. But under GDPR and UK GDPR, you broadly have 1 month to comply. But of course, if a SAR is complex, you can extend time by 2 months. And in the workplace context, as a soft rule, you need to assess this every time. But because of the complexity of an employment subject access request, there might be ongoing litigation, there might be a complaint. Often we see in the workplace 7 or 8 different SARs coming in at the same time, all about different things. There'll be lots of third-party data and so on. Potentially, you can argue it is complex, certainly in the UK, and you can extend time. But of course, you then get into a battle with the data subject, why have you extended time and so on. The key thing to understand is what do we need to provide? And a data subject will think you need to provide me with everything because that's what they want. They either want to know everything or they want to put as much pressure on you to have to look through 1 million documents or 1 million data sets. But of course, the answer is no. There are certain limits and exemptions in place that allow you not to provide certain documents. The first one is, of course, we're only talking about personal data here. I haven't written this on the slide, but we're only talking about personal data. So although my name might be on many millions of documents at Lewis Silkin, in the main, those documents don't really contain much further personal data about me. If I'm listed as attending a Lewis Silkin board meeting, for instance, unless that board meeting is about me and talking about me all the time, which obviously I would love because I'm exceedingly vain, in the most part, it's not about me. So the only personal data I'm really entitled to is that small attendees, Alex Milner-Smith. Now, lots of data subjects don't understand that, but you can tell that does require quite an onerous review to separate the personal data from other data. Secondly, Article 15 for GDPR and indeed UK GDPR makes absolutely clear that the right to retain a copy and receive a copy should not adversely affect the rights and freedoms of others. And indeed, recital 63, which accompanies the GDPR and UK GDPR, adds a little bit of colour to this. That right should not adversely affect the rights and freedoms of others, including trade secrets or intellectual property, and in particular, the copyright protecting their software. However, the result of those considerations should not be a refusal to provide all information to the data subject. So we have some scope there for protecting third-party data, for redacting confidential information, for making a balancing test about whether the provision of data to me is going to affect other people and our corporate enterprise. In the UK, we've gone even further by having very, very clear exceptions set out in the Data Protection Act 2018, very clear balancing test about third-party data, clear exemptions about legal privilege, and so on. And we have, in addition, we have a large and very useful 30, 40-page guidance from the ICO, where they give examples of what's acceptable and what's not. And we equally, both in Europe and in the ICO guidance, have concepts of proportionality. It's getting slightly less in Europe, but we'll talk about that later. So in the main, it can be onerous, but it's not as onerous as perhaps you might think. So let me just check that I didn't miss a slide there. No. So before we go on to Lionel, this is a nice segue into Lionel. As I said, this is not just a capital E European issue. Similar rights exist in Hong Kong. We have a Hong Kong office and have dealt with many, many subject access requests under the PDPO. They're in California's CCPA, they're in South Africa's POIPA, they're in the Brazilian law. It hasn't come through yet in India because of all the machinations around agreeing the text, but it was in the new Indian law. I think it's in the Vietnamese law, I think it's in the Thai law, it's in the Japanese law, as I say. I think it might even be in the Chinese law, but I'm not going to comment on that. But as you can see, it is everywhere around the world. And the constructs that I've just talked about from a European perspective are things that at least are recognizable in a worldwide, with a capital W context. And with that, I am going to hand over to Lionel. Lionel Tan and I have worked together many times as a brilliant lawyer. And in Singapore, as we'll hear, there are a number of issues with subject access. We can see there a wonderful skyline. Lionel's office is somewhere in the middle there. I think he's probably sitting in it now. So I'll hand over to you, Lionel, and do tell me when you want me to move a slide forward, Lionel.
Sure. Thank you, Alex. Thank you for introductions. Thank you. Could I have the next slide? Okay. So yes, what Alex said was perfectly true for Singapore. We do have similar access rights for subjects. In Singapore, we call it the access obligations. One of the obligations under our Singapore's Personal Data Protection Act. So we do have this quite similar rights. So any individual can request for access of their personal data that's in the possession, control of any organization, and they also can ask, how has that data been used by the organization for the last 1 year? So we have that aspect as well. Asking for certainly for the access to all the personal data and exactly how it's been used for just the last 1 year. So that's a particular date that has been provided. Alex, next slide, please. Okay, so this issue of proportionality, which Alex talked about, yes, we also have that principle. Your organizations are required to provide access. However, if they can weigh the burden or expense of providing access would be unreasonable to organization or disproportionate in individuals' interests, or if the request is otherwise frivolous or vexatious. So I suppose those will be certainly some subjective considerations to be made, but our regulators, the PDPC, have come up with some guidelines to explain to people, what would be a reasonable or unreasonable request, what would be frivolous or vexatious. So we do have certain guidelines that we can follow. Likewise, I think for the GDPR is within 1 month. In Singapore, we have to provide the access within a reasonable time. And it's recommended if you cannot provide within the 30 days, you need to go back to the subject and explain why you require more time. And again, in Singapore, we are allowed to charge an administrative fee on a cost recovery basis in order to gather all the data and provide it to the applicant. So I think, and you can actually ask for that upfront. You can ask for a deposit to be paid as well. In terms of, let's say you have to get another vendor to go through your system. Maybe they've asked for access requests for CCTV footages, right? You can actually get a vendor to come in, go through them, and also understanding that you cannot affect other subjects' rights. You have to actually blank out every other person's faces in that video with that person's, with the applicant's image, right? And you can ask for some reasonable fees and get a deposit from the applicant as well. Okay, next slide, please. Yes, so we don't have that many cases on reported cases on access rights, but as Alex mentioned, we do see some in practice where for employees they are asking for certain access as to the information as to perhaps why they didn't get employment, why they didn't get some increments or bonus, and try to find out perhaps is there a way that they can, in terms of settlement, in terms of negotiated for negotiations on that. But we do have one reported case, and the applicant's name is redacted, and as you will understand from this case why it's redacted. But it's brought against HSBC Bank in Singapore, and this individual based in Singapore, he applied to HSBC for a credit card, right? And he was unsuccessful, and perhaps that's why his or her name has been redacted. Then sought access to HSBC's internal evaluation report when deciding on his application. So he made access requests to say, what was his personal data, how was it evaluated, why, and perhaps trying to find out reason why his application was for credit card was turned down. So HSBC did provide a copy, but then redacted data on the basis it was some opinion data kept for evaluation purposes, which is an exception for disclosure under our PDPA, right? So because the principle is that under PDPA, that can be kept as confidential. So they refused, and then he was not satisfied, and then he sought a review from our regulators, the PDPC. Alex, next slide, please. And then so the PDPC held that this redacted data was opinion data because it was how the bank evaluated, right? And it was solely for evaluation and fell within our exception. And therefore, HSBC was correct. It was to not disclose or provide access request to the individual for that particular piece of data, which was actually what the applicant was always seeking for. And they said, well, the policy is that such opinion data used for evaluation can be kept confidential, right? Another interesting point for this case was for the redacted opinion data this was auto-generated by HSBC's proprietary algorithm that determined the suitability of this person and others for the credit card. So what the HSBC said, look, we can't give you why your particular application was rejected. However, we do have all these guidelines, internal guidelines from the bank as to how the technology was used in terms of determining your suitability. And then they of course showed that to the applicant. So they said PDPC, our regulators held that HSBC in this case had acted reasonably by providing this information. So I think the bottom line for all this is a good case in the sense that there are exceptions that can be relied on not to provide. But if there's going to be, in terms of AI automation being used, then the good point is to provide the applicants with how perhaps some guidelines that how the decision was made. Okay, I hope. Okay, Alex, I think back to you. That's enough for a bit about Singapore.
Lionel, very interesting. I think just in summary, there are a few more limits, I think, in Singapore. I would say sensible limits, but I always say everything. I like to limit everything. And there's some similarities, but I think just to put a European with a capital E spin on that, on the HSBC case, we certainly outside of SARs have to provide information anyway about the use of AI and the use of algorithms. Even within the SAR context, actually they are entitled under 15 15DE or whatever it is, 15.1E or whatever, for information about automated processing within the SAR right. But equally, it's fascinating about the evaluation exemption. It just doesn't really exist in Europe. You could probably shoehorn it into proprietary decision making and so on. But the way it often comes up, and Linda and I used to talk about this in the past before GDPR, I think. But in Ireland, I think at one point, third-party opinions, there was an exemption. I think Linda's gonna, she is nodding, because otherwise sometimes I just talk a lot of nonsense, as people know. But anyway,
but just to say, there is still an exemption, but it's really hard to use in the employment context. Because managers are expected to have opinions about employees.
Well, that's right. That's really how we'd look at that. In Europe is, we'd certainly try to balance third-party rights and so on if it was Inga's opinion about me. But at the end of the day, if Inga was my manager and it was just in the course of her role, we might decide, well, you have to provide that, because although it's Inga's personal data, it's also my personal data. However, if Inga was talking just personally to someone on a WhatsApp, which may or not even be within the scope of controllership, you might make a different balancing decision, certainly in the UK. But it's fascinating. I mean, and one final point, Lionel, because we could have an hour just on Singapore, but this is, as I said, sort of speed dating. And Lionel, been a wonderful date. Thank you. Fees. I mean, how much are we talking about? Surely a data controller could they charge the legal fees? I mean, how much, is there a limit to the fees? No. It's
cost recovery purpose. So if let's say you have to spend a couple of hours to access it, maybe you can charge some person's hourly charge out rate for that hour. But we've seen, like, for example, we have to engage an external vendor to let's say go through CCTV footages and then extract them and remove others. So we will get the external vendor, ask them to give a quotation for the kind of service they provide and how much time, and then we are entitled to ask the subject to make payment. So again, it's always reasonable fees. It's on a cost recovery basis.
And then I assume sometimes data subjects pull out if they don't want to pay $1,000 or whatever. Yeah, how interesting. Okay, Lionel, as I say, we could go on, but speed dating. We'll come back to you later for one final thought or if there's any questions there aren't as yet. Moving on to Roxana, I don't think that is your offices, Roxana, although it may well be, but moving on to Romania, and Roxana, do let me know when you want me to move on the slide.
Please do, and thank you for being curious about data subject rights and right of access. In Romania, frankly, we don't have too much guidance beyond the wording in the GDPR on the requirement to provide personal data, but we do have some particularities when it comes to the practice. And if we look at the practice of the Data Protection Authority based on publicly available information, it's clear that data subject rights in general is one of the main triggers of complaints received by the DPA. And because the DPA is a very small authority in Romania, they do not normally do too much proactive work, which means they react to complaints. When you have an increased number of complaints on one topic, you see the authority becoming more active in that area. And this is why it's very important not to underestimate the relevance of properly managing data subject rights in general and right of access in particular. What we've seen from the authorities' practice recently is the fact that they are very prone to applying fines in the recent 2 years, I would say, on the breach of the obligation to respond to data subject requests on access right. We've seen sanctions ranging from warnings to 5,000 euros. I know it doesn't sound like much, but when you look at the practice in Romania and you realize that in the last 2 years, the highest individual sanction was of 10,000 euros, 5,000 euros gets a different perspective. And the authority goes for this kind of fines when they have an evident breach of the obligation, like completely ignoring the request of the data subject or missing the deadline in an obvious manner without going back to the data subject and explaining that you need that extension that Alex mentioned previously. And out of all there are 8 sanctions that are being published, but we pretty much know that for any sanction that the authority publishes, there are probably 2 alike in the background in the recent past. One aspect of concern for us is the fact that our authority has taken a view that the data, the right of access and that provision that say individuals can request a copy, it also applies to documents. We have pushed back on that that interpretation on various occasions. However, until now, they haven't moved from that, and they routinely order controllers to provide copies of video recordings under the right of access request, while blurring the faces of other people than the data subject, but still they impose that obligation. We've seen even a supermarket being sanctioned twice for refusing to do so in a very short period. This is why actually, because of that position of the authority, we're very keen and following this subject at the level of the European Courts of Justice, because you may know that there is a case filed, a preliminary request submitted by the Austrian authority in a case involving the Austrian authority. And there we've seen the opinion, the case number is 487. We've seen already in December 2022, the opinion of the Advocate General saying actually very clearly that copy of personal data under the right of access does not actually involve the obligation to provide copies of documents, including those personal data, or copy of or something extracting from the databases. And we're actually very keen following that case to see if ultimately the Court of Justice will say the same as the Advocate General, because that would allow us to have another occasion to have to correct the practice of the Romanian Data Protection Authority on this topic. Until then, you need to be careful and you need to treat very carefully any requests that involve request of copies of documents, not only of the personal data.
Yeah, thank you, Roxana. Just before that's let me just move. That's very interesting. We're going to go on to Belgium in a second. Just because we've had a question on the Austrian Post case, I might ask you a question now about that because I know you're well versed in that. But just before that, I mean, in the UK, there are two ways that one responds to SARs. You know, sometimes we do provide copy documents with heavy redactions. Other times we extract data, and we're a little bit more relaxed in the UK about it. It is really copies of the data. So that would be very interesting to see if that spreads around Europe, because that would be more onerous than I think that some of our clients do approach that.
Yeah, in Romania, it's the same, especially for companies that have a very well-developed digital footprint. It's a matter of opportunity. So they may opt to give that kind of access, even have interactive platforms for data subject rights, so that individuals can extract what data they deem relevant and they need. However, you have to consider that digital footprint in companies in Romania is, I would say, less than the average at EU level, which means that a lot of information is still in paper format, not with a lot of archiving rules, but not necessarily digital archiving rules. So that practice of the authority makes it very difficult when you end up having to look at legacy data going back more than a few years, when, let's say, some apps have been developed but do not cover the full extent of the company's interaction and data collection activities.
And it's a nice point around, it leads on to, if your excuse, as we've seen some of our clients in the UK and indeed Ireland say, we have so much data, we can't look at it. It can then lead into a regulator saying, well, why have you got so much data? Your retention policies are flawed. But just because of time and because of the question, so there is some commentary on subject access in the Court of Justice of the European Union Austrian Post case released last week.
Yeah.
Can you just, Roxana, just in a minute or two, no more than that, just give us sort of 2 or 3 key points in terms of subject access in that case?
Promise. Yes, actually there are a lot of cases coming on from the Austrian authorities, and the case they're referring the judgment was published on the 12th of January, so it's very fresh. And the question in a nutshell was whether under the right of access, is the controller obliged to disclose specific identity of recipients? So not only the category. And the answer of the court was yes, they must be when the data subject so requests. And they also provided 2 cases where this would not be necessary, when it would be impossible at that moment for the controller to provide the information, or if the request is manifestly unfounded and excessive. There are a lot of questions still coming when reading that judgment, but in a nutshell, you need to check your records of processing to see if you have that level of detail in the records of processing to be able to support this, because actually the records of processing only requires documenting categories of recipients. So it's not the same wording as in Article 15. But still, you need to do that in terms of reaction to this judgment. And we also started recommending clients to check their internal processes policies to make sure that they have this integrated, because if they can provide that information but require a lot of digging time, it means that you need to make sure that you make use of that extension possibility under the GDPR in terms of the deadline to move from 1 month to 1 + 2 months. And there are a lot of, frankly, questions triggered by the judgment, like, do we have to identify recipients in the information notices? I would say no. Because the judgment says that this information, specific information, needs to be provided to data subjects on a request. In the privacy notice, I don't see the need to do this. However, do you need to disclose unwanted recipients, those that had access to data as a result of data breaches? It's a sensitive question. And again, the question can come. My recommendation would be put this assessment of the impact of this judgment on the to-do list in the coming period, because there are a lot of fine-tuning elements that as an organization you may need to look at and adjust your processes.
Yeah, it's a strange one because that decision has some positives in relation to litigation and de minimis thresholds and so on, which we'll probably do another session on. And yet, Court of Justice of the European Union doing the usual thing, being very, very pro data subject. That's very good. Roxana, thank you for the summary of Romania and the summary of that case. And I hope that answered the question of the questioner. I am going to move on now. Maybe Inga's computer there, I don't know, but I'm moving on to Belgium. And Inga, thank you very much. I will move on to your first slide.
Hi, Alex, thank you. Hope you hear me all right, because I had some great. In Belgium, before the GDPR, we didn't really have a practice in Belgium of exercising data subject rights and the rights of access. But recently, in the last 2 years, we've seen an increase, especially as in the UK, as you mentioned before, in employment matters, and certainly after dismissal. So what happens is that a person is dismissed, they will ask, and we see that some lawyers are typically going to do that, will ask for the personnel file of this employee, and the aim clearly is to find out whether there are grounds and supporting evidence for the dismissal. If it's not the case, then they can ask for extra damages based on discrimination or unreasonable dismissal. And it's not so easy in Belgium to give advice to our clients, because we do not have, and I think Roxana mentioned the same, we do not have any specific guidelines from the Belgian Data Protection Authority on exercising SARs. There are now, of course, the EDPD guidelines that you mentioned, but I find them very theoretical, not very pragmatic. So what we would typically do is also use the ICO guidelines. And that is why, of course, it's very interesting in Belgium to follow up on the Data Protection Authority decisions. And I included just 3 of them. There are a bit more, but just 3 decisions that can give some guidance on how the Belgian Data Protection Authority is dealing with SARs. So the first case is on a hospital that fired a doctor who was in charge of a department. They did an audit on this department, which was very negative, especially on the management style. And so they fired the doctor who was in charge of that department. The audit was done by an external company. So what happened? The doctor asked for a copy of the audit report, and the hospital refused based on a number of arguments. First argument that they used was that there were no personal data included in the report, because they said it was on the department, it was not on the doctor itself. That argument was not accepted, and it was confirmed that there were personal data, namely the name of the doctor, of course, but also the appraisal, the opinion that was given on the way that the department was managed. And so in opposition to what applies clearly in Singapore, in Belgium, opinion data are really being confirmed as being personal data that should be provided in the course of a SAR. Second argument was copyright, which was not accepted either. And then the third argument was that it was a confidential report, which was not accepted by the Belgian Data Protection Authority, also because by then there was litigation going on and the report was given as evidence in the course of litigation. So that's an important element that we take from this decision, that whenever you are confronted with a SAR as an employer in a dismissal case, you have to provide all documentation that might eventually be produced as evidence in later litigation, because if you would produce it as evidence, then clearly it will be considered as personal data. Second decision, you can go to the next slide, Alex, is of October 2020, which is also a bit typical in Belgium, that when employers are confronted with a SAR, they will think they have lots of time, and they will not realize that the 1 month period is really a mandatory time period. And so this is a case where an employee asked 4 times to have access to appraisal forms in 7 months time, and they were eventually ordered to provide the data within a 14 days delay. They were referring to the fact that they had to check whether the rights of others were not at stake, but this was not accepted as a clear ground for delay or for an extension of the 1 month period by the Belgian Data Protection Authority. And I think the last decision is the most interesting one, which is of February 2021, and it concerns an IT consultant who was also an employee representative, meaning in Belgium a protected employee who cannot be dismissed. And there was a dispute on the functioning of this IT consultant, and clearly, just to bully the employer, I would say, the IT consultant introduced an access request demanding lots of documents. And so the employer provided lots of personal data, but there were 3 elements of discussion. And the first one was the notes and comments. So personal notes and comments made by the manager of the IT consultant and the HR responsible, which were refused by the employer. So they did not want to give that notes and comments because they said that would really affect the privacy rights of the manager and the HR responsible. And this argument was not accepted by the Data Protection Authority. They did accept that the rights of others are to be respected, but you have to do that by anonymizing the data. So they could leave out the name of the manager and the HR, but they would have to give the content of those personal notes and comments. And it's interesting that the DPA will in this decision also note that as an HR responsible, you have to be aware that any comments or any appraisal that you provide in the personnel file of an employee can be requested by that employee. So you need to bear in mind what information you store in these personnel files. The second one was on the IT logs. So this employee asked, and it was an IT consultant, so he asked for all possible IT logs, all the times that he ever logged on the network of the company. He had a long career, so it would have been an enormous work to gather all that information. And this here, the Data Protection Authority accepted that they should not provide all the IT logs based on the proportionality principle. So what they said was that that enormous search would not be in balance with the benefit that the IT consultant could get from those IT logs. So that is very interesting because it's the first time that the Belgian Data Protection Authority has confirmed the proportionality principle. And then the third one, which is also very common, I think, in SARs, also in other countries, is that the IT consultant asked to have a copy of all the emails in his mailbox. But this IT consultant was still working for the company, had, of course, access to his own mailbox. And so the company refused to provide copy based on the proportionality principle again. And that was, strangely, that argument was refused. They also refused to provide the emails based on the rights of others to be at stake, because the data protection authority said, yeah, in principle, you have to provide those emails, but you would then have to anonymize personal data of others. But in the end, they did except that the company did not have to provide the copy of all the emails based on the confidentiality of company data. So there was confidential company data included in the emails, and based on that argument, the company did not have to provide a copy of all the emails in the mailbox. I think this is also interesting because in other countries, having access to your own mailbox would, as I understand, mostly be refused based on proportionality, which I think is a better argument to refuse it. And yeah, would be interesting maybe, Alex, to find out how that would be treated in the UK.
Yeah, I mean, that's super interesting, Inga, actually. Three recent and very interesting cases. I mean, the proportionality thing is interesting. It's good that the Belgian courts are looking at that. It's obviously in slight contrast to the guidance that you referenced from the EDPB, where they don't seem necessarily to recognise the proportion of confidentiality, even though in the whole aquis of EU law, proportionality should apply to every piece of law, but they obviously know the law better than me, apparently. But let's hope that happens, because proportionality is something that is used all the time in the UK, and the ICO references it in its guidance, and in all the relevant real cases, there's been a real push to sort of just that you shouldn't really need to look at, you don't need to turn over every stone and so on. And equally, we've had many clients talk about the employee having access to his or her email, or still, is that a ground for refusal? It might not be for a total refusal, but at least allows you to hone down your searches and so on. I mean, the way we tend to approach all of this in the UK is, if someone asks for Inga Verhelst, and you've been at Claes & Engels for whatever, 10, 15 years, there'll be millions of documents. And we say, look, there's millions of documents. We want to be a good data controller. We're going to reduce it. We're going to add in other search terms, Brussels, whatever, so that we get down to 1,000 documents. So we're always giving them something, but still trying to do it within a proportionality argument. What we never really advise is the idea of, no, we're not providing anything, because it could just be such a bad look and you're on the back foot. But that last case is really interesting, covering all kinds of different issues around third-party rights and so on. So, and the anonymization of protecting the rights of other persons is a very difficult one, because we have this a lot in investigations, where someone is asking for the investigatory notes relating to them. Now, if it's an appalling case of harassment, 20 other people might have been interviewed, and you can anonymize names, but only I was by the water fountain at the Christmas party. So you have to, it's an impossible kind of burden for data controllers across Europe and in the UK. Luckily, in the UK, we have a few cases which say, as long as controllers are making reasonable decisions, we, the court, will not go behind your discretion. But just that balancing test on third-party data, one person's this balance is another person's this balance. So it's, I just think, final point, we've got to move on to Linda. That point around the EDPB guidance just being wholly divorced from reality, you didn't quite say that, but impractical. It really, I will say one point, it's one of the first pieces of big guidance that has come out since the UK left the fold of the EDPB. And I will make a big comment, but I don't think that guidance ever would have been released if the ICO was still contributing to it, because they would have just said, data controllers cannot do anything with this guidance, because you've essentially said you have to do everything that a data subject wants. And this Austrian post case similarly goes down that line, and you're going to end up with a situation where all companies are doing is responding to SARs. I'm being facetious, but it's down that line. Inga, as always, wonderful. I'm going to hand over to Linda.
Thanks.
That is Linda's house. She's very security conscious.
That is, yeah. Do not ask for any of that data. It's really interesting.
Stop me visiting Linda,
yeah. It's really interesting hearing the conversation. And even on the topic of the European Data Protection Board guidance, I have bad news in terms of the recent guidance issued by the Irish regulator is almost like a summary of what's in that guidance. So they're very much following it. I think anyone who's attended these sessions where I've spoken about Ireland before will know that subject access requests are a really common feature of the employment disputes landscape here, particularly because the way our employment cases work, there's no formal discovery process. So if you are intending on going into litigation with your employer, you will more than likely put in a subject access request. And they're very often used, as Alex said at the beginning, for leveraging settlement negotiations. So very often we'd see you'll get an angry letter from a lawyer about how terribly the employee has been treated. And within that, there'll be a subject access request being submitted on behalf. So really, really common. So I suppose seeing a lot of employee subject access requests means there's also a lot of complaints to our regulator about them. And we can see that from the recent reports from our regulator as well, that they're still what their main source of complaints and the main topic that they receive inquiries on is subject access requests. So it's a huge topic in Ireland. So we have seen a huge backlog, but that's actually clearing. And in the 2021 report from the regulator, they were very pleased to announce that actually they concluded 170% more access complaints than it received in that particular year because they were dealing with the backlog. So they really have been working hard on clearing the backlog. So while that's good news for data subjects, I think for employers, it does mean in Ireland, you will be faced with having to answer the regulator a lot more quickly now if an employee does put in a complaint around how you've handled their subject access request. And we are seeing the regulator being a lot faster at reaching out to employers when they've received a subject access request complaint from an employee or a formal complaint. So you could end up before the regulator a lot more quickly. And 42% of the complaints they received in 2021 were actually related to access requests. So you can see it's a huge body of work for what is an already very busy regulator in terms of data protection. I think the good news for employers is we still aren't seeing fines in Ireland for subject access request breaches. It's mainly reprimands and directions to actually remediate SAR response processes. So we're still very much in that space. But I think the Irish regulator's patience is starting to wear thin on how data controllers are responding to these access requests. And obviously, as we know, generally our regulator is under a lot more pressure from their European counterparts to start issuing more and more fines on different topics and more increased fines. So I think that is something we are going to see a change on. And we do, the annual report for 2022 will be issued shortly. So we'll make sure that we update our Use Laboris members on any interesting trends there. I think it's usually around the end of February. So I'm sure we'll see a lot more stats there around access requests and how the regulator thinks they should be dealt with. Interestingly, from the report last year, there is a whole section dedicated to access requests, and it's quite clear that our regulator is very concerned about patterns that it's seeing and that it's identified where controllers are not responding to subject access requests at all, or where they're not even responding to the regulator when the regulator reaches out to them to find out how they've managed an access request or to deal with a complaint. So they're quite concerned around that. They have highlighted some of the main failings that they see when they are looking at these complaints. And the three main issues they see are data controllers not carrying out adequate searches, and there can be a lot of back and forth on what the search parameters should be. Data controllers not advising the subject that certain data is being withheld and why they're withholding it. So I think we always say this on these sessions, make sure that whatever you're writing to the individual, it's as if you're writing to the regulator. And then the other main area they see is not responding within the required time frame. And I have some points to make on that as well, which unfortunately aren't that helpful for employers either. Now, as part of the report, they did say they were going to issue further guidance on various topics, including subject access requests. And they have held true to their word there and issued updated guidance just in last October 2022. So it's more detailed than what we had previously. It's still only 20 pages though, so not a huge volume of information, and it does accompany an existing FAQ document that they had published. I think, unfortunately for employers, it doesn't really help with being able to limit the scope of employee subject access requests. It again reiterates a lot of what's in the EDPB guidance about how broadly they should be considered and how broad the definition of personal data is. So we see a lot of kind of similar language in the Irish guidance. I won't go through all of it, but I'll just pick out some of the points that I think are interesting for the participants today. In terms of when the time starts to run for a subject access request, I think it's slightly less helpful than the European data protection guidance, because it really drives home the obligation on a data controller not to overlook an access request, and gives the specific example of where an email is sent to the wrong department and isn't sent to the right department for a few days. The clock will absolutely start running from when it went to the wrong department. So again, I think that really, and in the guidance, they really drive home the importance of training your staff how to recognize a subject access request, and all that information that we've seen before around, it doesn't matter if it doesn't refer to the GDPR, it doesn't matter if it doesn't refer to personal data, you still need to know that it is an access request and treat it that way. So I think there's a lot less scope for arguments around when the request was received. And I think employers need to approach that quite conservatively. It's better to act on the earlier date and not end up in difficulty down the road. There is some guidance, they seem to go into this a lot around verifying data subject identity and when that's proportionate. It's interesting, it's one of the only areas proportionality is talked about. But I think in the employment context, having to go through a verification process for an employee is really not going to be seen as necessary in most circumstances, unless you can show the regulator why you had very serious reasonable doubts that the person wasn't who they said they were. In terms of trying to seek clarity around requests, I think it's not helpful. It does set out that there's no reason that a data controller can't go to the data subject and look to reduce the scope or look to clarify what their request is about. And it does say that that is a helpful thing to do. But it's very clear, and it specifically says, I'm going to read out, it says, although it is in the interest of the data subject to cooperate to speed up the process, the data subject is not obliged to answer, and a data controller must comply with the access request, even if the request for clarification remains unanswered. So that's quite clear. Yes, of course, you can go back to them and look for clarity, but you need to just keep moving on and deal with everything. So not very helpful there, I think, for employers. We've always had a bit of confusion around when the deadline date actually arises in terms of the month, and when a deadline falls on a weekend or a public holiday. It's mirrored what's in the European data protection guidance on that. So at least we can be quite clear now on when the deadline is, and if it falls on a weekend or public holiday, yes, you can move to the next working day, because that was always an issue for employers in Ireland as to when the deadline was. I think this is really kind of worrying, but it does really drive home that they think you should be answering it as soon as possible, regardless of what the deadlines are. And they've put in a recommendation that data controllers should actually be trying to comply with access requests within 15 days where possible. I don't know why they've done that. There was absolutely no reason to do that. But I think it really points to, in the future, we are going to see more scrutiny by the regulator as to why employers took so long to respond to access requests. And I think being really, really clear when you send that first response saying that you need more time, being very clear on why that is and being able to stand over it. So I think we might see the DPC start to disagree with why people have sought the 2-month extension in the event of a complaint. So I think that is definitely a space to watch. The guidelines do set out the structure of what they expect a response to look like. So I think if you are responding to a subject access request as an employer, it's a good idea to get out this guidance and see if your response goes through that. I was going to go through some case studies as well, but I think we've probably kind of covered most of the topics on them already. I think just getting to that interesting case that my other panelists talked about, in Ireland, you would certainly be expected to provide a copy of the CCTV. You could rely on the third party exemption, but the regulator in most of those case studies has said that's not a reason not to provide it. You just have to redact the third party data. So we would definitely see that you'd have to provide it in most circumstances.
Linda, that's fascinating. There have been a couple of questions. We are at time. I think we're just going to go 5 minutes over for everyone, just so you're aware. Obviously, people will have to drop off, I'm sure. Linda, that's fascinating. Just on CCTV, just from a UK perspective, we do sometimes just provide stills from CCTV. If all someone is doing is standing there and there's no sort of interaction, we obviously sometimes have terrible CCTV issues where someone is punching someone. That's a different issue. But if it is, I want to see all my CCTV and literally all they're doing is walking into the reception each day, we do sometimes provide a still. I'm going to run through these slides very quickly. There have just been a couple of live questions, which I'm going to do literally as quickly as possible. So would an employer be required to provide data on messages about a data subject sent through communication platforms such as Slack, WhatsApp, and Teams? From a European perspective, the first question is, are you even a controller of that data? If WhatsApp is not an official communication tool at work, and people just use it personally, I might WhatsApp Linda or whatever, then it's not within your scope as a controller. If, however, Slack, WhatsApp, and Teams are official channels, then yes, potentially, if there's personal data contained in those messages, it might be responsive, but you're then absolutely into probably some of the hardest questions around third-party data. I gave the example earlier where I might be sending information that's very clearly part of my role, and you can't really talk about third-party data protection there too much. But on WhatsApp and Teams, it's a little bit looser. You might send a loose message, or that shouldn't, obviously, and I don't. I'm just for the sake of heuristic. You might send a message saying a little bit loose, oh, that person's this, that person's this. You might really need to think a little bit more in detail about that balance of third parties. And obviously, from a Singaporean perspective, you might even have some more exemptions. So that's that question. Next question. At what point does the privacy of other employees override the need to one person to receive their SAR? That is the balancing test I'm saying. There is no answer to that. You have to just look at the context and the balance. And if it's vanilla third-party data versus a data subject who is, I don't know, engaged in a terrible disciplinary or something, and the data is super important for them to say, the balance might be in favor of the subject access request maker. If, however, in relation to the second question, if you have a confidential investigation process and you make it clear that the complainant raiser has no right to the final report, do the witness statements of that investigation process become discoverable under a SAR? Possibly, but in relation to the third-party witnesses who might be mentioned in that report, if it's been made clear to them that they will be contributing confidentially to an investigation process, then you might not be able to provide their data to the data subject. And you might have to make a different balancing exercise decision in terms of whose data rights trump whose data rights. So you can see it's a very complex issue, and it's quite hard just to take a blanket approach. And my one piece of advice there would be just to think about it and get a review protocol in place so that any reviewers all make the same decisions as well. We have had some horror shows where at some clients, multiple reviewers have been reviewing multiple different documents. One person has taken this approach, another person has taken this approach, and it just is very confusing. We'll leave these practical considerations for another time, bar this one. I really think you should think tactically at all times when you're dealing with SARs. What is the data subject trying to achieve? What are they really interested in? Who is my audience? And I'm afraid your audience may be a regulator. So if you're always trying to make sure that anything in writing that you send to a data subject is hitting a point that regulators would like, Linda just mentioned one there. If truly the DPC wants you to respond within 15 days, and you're having to explain why you can't respond within 15 days, just do that in some detail because you know it might be in front of a regulator later. So I'll just do this very quickly, but there's obviously some proposals in the UK, in our UK tweaks to data legislation, not coming through yet, may never come through, but we're going to make it potentially slightly easier to refuse SARs if they're vexatious or excessive, as opposed to manifestly unfounded, okay, which is currently in the GDPR. So we might change that. Of course, we have to be careful about not losing our adequacy status in the UK. The ICO's named 7 organisations in 2022 for failing to comply with SARs. They are releasing guidance all the time. Anyone in the UK, the ICO guidance, I'm afraid, compared to those in Europe, is very, very useful, very, very practical. And the ICO tend to take a very sensible and pragmatic approach to SAR regulation. I'll just run through this because they're not on, no one from Finland or Germany is here, or Sweden. Examples, this isn't just a Singaporean, Romanian, Belgian or Irish or UK issue. Finland, £750,000 euro fine for debt collection company for not responding to SARs, you know, there's an example. They didn't respond. Perhaps if they tried to respond a little bit, they wouldn't have been fined, but not an insignificant fine. France, 300,000 euros, failing to adequately respond. Germany, higher regional court finding that the motivation of a data subject their motive is irrelevant and you don't consider it. That goes back to the very beginning of the slide, of our slideshow, where we were talking about how important the right of access is. Belgium, I think you've already raised that, Inga. Sweden, the administrative court confirmed the DPA decision that right of access obliges the controller to disclose information regarding the specific recipients of personal data to the best of abilities if a data subject expressly asks for that. Similarly mirrored in the Court of Justice of the European Union case that Roxana was talking about. So there's case law all across Europe, sometimes contradictory, often, I'm afraid, very pro-data subject. Now, we really are over, and I was going to ask for final comments from people, but I think I'm not going to. I'm just going to say, as always, thank you, Roxana, thank you, Inga, thank you, Linda, and thank you, Lionel. It's really interesting, and I know I have to hand back over to Josabel. But thank you, everyone.